There were concerns over his views on racial equality when he was nominated to the Supreme Court. Some organizations expressed concerns about the fact that he had co-authored briefs that urged courts to release school districts from court-ordered desegregation. In addition to those concerns raised by the ACLU, the NAACP, which has long championed school desegregation, also raised those concerns. In the White House, he offered views that opposed busing. He supported legislation that would preclude busing, even in circumstances where courts had ordered busing in order to achieve unified systems from dual systems. Senator Barack Obama opposed his confirmation. His view was quite simple. Judge Roberts is very well qualified, but he has used his skills on behalf of the strong in opposition to the weak. And his cases, decided by his court on the issues of race, confirm the concerns raised during confirmation. One of the most important cases was the school segregation case called Parents Involved in Community Schools. It involved voluntary programs adopted by two school boards, one in Louisville, Kentucky, and another in Seattle, to use race as a factor in school placement decisions to eliminate racial segregation in those districts. So there were two cases, and the two cases were different cases. The court chose them so that the court would have an opportunity to opine on whether race could be used as a factor to create a diverse school district. The Seattle case involved no prior findings of segregation by a court or no school board policy to officially discriminate on the ground of race and pupil placement. But the district saw population trends and demographic trends contributing to segregation, as they saw that disparities in income limited the places where students could live. And so they thought that if they continued to abide by a strict neighborhood school assignment policy, that their schools would be virtually segregated. And so they use pupil race in some cases to create schools that were more balanced racially. Louisville, Kentucky had a different background. It was segregated by law. There was court-ordered desegregation for a number of years, but the district court decided to relinquish supervision when it concluded that in Louisville there was actually now a unified school system, or a unitary system. After that decision, the district used pupil assignment policies that took race into account in order to maintain desegregated schools. Once again, both Seattle and Louisville saw, as many school districts see around the country, that if schools do nothing, the schools will become segregated again. So the result in the Supreme Court is that the Supreme Court held that both plans were unconstitutional. Those who followed these cases thought that the Supreme Court might conclude that the Louisville, Kentucky plan was more palatable because it came on the heels of findings of intentional discrimination, and that the justification, therefore, for school board action might be stronger than in Seattle, where there were no prior findings of de jure segregation. But the Supreme Court did not see it that way. 5 justices found both plans to be unconstitutional uses of race. In particular, the justices who declared the plans unconstitutional were uncomfortable with using the race of a student as a factor in pupil placement decisions. 4 justices found the programs constitutional, and for these justices, their concern was that the legacy of Brown would never be achieved unless school districts were free within limitations, of course, to take race into account, to create diversified schools where students would have the opportunity to grow and learn with diverse classmates and thereby provide a foundation for our society to be a strong and diverse country. The viewpoints expressed in the opinion range from those expressed by Justice Roberts, Scalia, Thomas, and Alito, who gave short shrift to the school board's concerns that education would not be as effective for participation in a democratic society in a racially isolated education environment. They rebuff those concerns with the simple statement that the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. Justice Kennedy did join the majority, striking down the plans. He did agree that the use of race as a basis for pupil assignment was unconstitutional. On the other hand, he said that our society was one where race had played a role in opportunity, in housing, in income, in jobs access, and that these problems, these societal issues, had affected the ability of people to grow up in neighborhoods where they could experience a diverse environment. And so while he rejected the idea that race should be used for pupil placement, he did hold open the hope that the concern about whether schools are racially diverse is a concern which school boards might pursue. And he left open the possibility that diversity could be a compelling interest nonetheless. So he struck down the program, but said to the school districts, "We'll try something else other than assigning students to schools on the basis of race." Justice Thomas said that the Constitution is colorblind, and this is not a new comment. He has taken this position for some time, that there's no circumstance under which race should be used to make any decision. Actually, he did say that race could be used to make prison cellmate assignments in a prior case, but generally has taken the position that race can never be used in any setting, especially in a school setting, to promote any objective, including diversity. The Constitution for Justice Thomas is colorblind. And the strongest voices, though, in favor of permitting school districts to use their expertise and experience to create learning environments in which students may prosper and learning environments that will provide a foundation for our society are Ginsburg, Breyer, and Souter. Among other things, they argued that democracy requires an educational environment that is reflective of a pluralistic society, and that democracy will not flourish in our country unless our children have the opportunity to be educated in that ever more diverse educated in order to exist in an ever more diverse society. So these are the strong voices. So in 2007, 4 justices strongly supported school districts' efforts to voluntarily desegregate their school districts. 4 justices were adamantly opposed to those efforts, and 1 justice, Justice Kennedy, we might argue, had it both ways. On the one hand, he voted with the majority to strike down these programs that school districts crafted. On the other hand, he said to school districts that you may take race into account, that you may take the use your view that a promising education environment requires a diverse educational environment, but simply may not assign students to schools on the basis of race. And so that's why we call Justice Kennedy a swing justice. He leaves open the possibility that he might be persuaded by subsequent arguments, and at the same time votes with the majority to strike the programs down. He gave a similar performance in prior cases.